I speak on behalf of the cooperating group of non-state, non-police core participants, a group of individuals and organisations who were spied on by the Special Demonstration Squad and the National Public Order Intelligence Unit. That is, all of the non-state core participants in this inquiry, apart from Peter Francis and the former wives of undercover officers. It includes the families of deceased children whose identities were used by undercover officers. The group is coordinated by Lydia D'Agostino of Kelly's Solicitors, and all of the recognised legal representatives of the non-state core participant group have seen and contributed to the content of this opening statement. What I have to say supplements the statements that have already been made and those that will be made directly on behalf of individuals and groups by their instructed lawyers, and in some cases by core participants in person. This statement focuses on the common themes and concerns that are shared by them all. The central theme is their desire to know the truth about political undercover policing and to see lessons learned for the future. They want to know what was done to them personally, and they want to know how it came to be that secret policing operations were permitted to infiltrate and undermine civil society in the United Kingdom and beyond for over 50 years. You, sir, began your tenure as inquiry chair, as had Sir Christopher Pitchard before you, by committing to discovering the truth. In your initial statement on the 20th of November 2017, you said, "The inquiry's priority is to discover the truth." Unfortunately, sir, nearly every decision taken since then has reduced the inquiry's prospect of doing so. The central problem is the over-reliance on the police to voluntarily give themselves up to scrutiny, notwithstanding their appalling record in that regard in all of the multitude of reviews, investigations and court cases into the activities of the SDS and the NPOIU that have preceded this inquiry. The second critical problem is the lack of weight given to transparency in this inquiry, not only as an end in itself, but as a means of getting to the truth and being seen to do so. It is very welcome that these opening statements are being broadcast online. However, under current plans, as soon as the evidence begins, the publicly accessible broadcast will stop, and access to seeing and hearing the evidence will be restricted to just 60 core participants and lawyers who are willing and able to take the risk of attending the venue in central London. In light of the latest COVID restrictions, there will be no public access to the hearing rooms at all. There will be some accredited media who are allowed to attend. The lack of public access is notwithstanding that those giving evidence will be relaying events that happened 50 years ago, and it is stretching credulity to suggest that there would be any significant risk to any of them of their evidence being live streamed. You have said, sir, that the reason that it's not possible to live stream the evidence is because of the risk of breaching restriction orders. However, as Mr. Menon said in his opening statement on Wednesday, if there is such a risk, it can and should be overcome, just as it is in other inquiries, such as the inquiry into child sexual abuse, which plainly considers matters of the utmost privacy and sensitivity. None of the restriction orders in respect of officers being called to give evidence in this phase was granted on the basis of any risk of physical harm. All were granted on the basis of the officers' wish to avoid any risk of interference with their private lives or damage to their reputations, or in one case, income. One of the officers, HN336, whose cover name is Dick Epps, even appeared voluntarily on a television documentary, True Spies, under a pseudonym. So the irony is, sir, that he spoke more openly on national television than he will do now in this supposedly public inquiry. Sir, on Wednesday, counsel for the designated lawyers officers complained that the open-closed divide in this inquiry means that the officers he represents have, to use his words, one arm tied behind their backs because they cannot speak openly and publicly about the valuable work that they did. So how does that sit with the fact that what prevents the officers in the present hearings from speaking openly and publicly about their work is their own applications for restriction orders, founded not on any risk of harm, but on concerns about damage to their reputations? If any of them is listening today, I wonder whether they might not consider that it is actually, on reflection, in their own interests to speak openly about their deployments so that the public can see and hear for themselves what they have to say. So you've granted the restriction orders relevant to these officers back in 2017 and 2018, at a time when the current situation was unimaginable. You did so on the basis that publication of the officers' real names would serve no useful purpose. At that stage, it was anticipated that the officers would give evidence in person, in a hearing room, which anyone who wished to could attend. The only consequence of the restriction orders at that time was that we would not be told their real names. The situation now is a world away. The consequence of these restriction orders now is that the evidence of these officers will not be seen or heard by the public, nor by the vast majority of core participants. Removing the restriction orders would now serve the extremely useful purpose of enabling this to be a public inquiry, at least this part of it, and it would remove the inevitably discriminatory impact of the current arrangements. So the refusal to live stream the evidential hearings serves no one. It perpetuates the ethos of defensiveness and secrecy, and it deprives those who have been affected, and those who wish to understand the trajectory of political undercover policing in this country from effectively participating. Reading the transcript is simply not the same thing as seeing and hearing the evidence being given. The non-state core participants respectfully ask you to reconsider this issue, sir, in light of the wholly changed circumstances in which we now find ourselves. In addition to the issue of live streaming, the non-state core participants would like to put on public record 4 fundamental concerns that they have about the path the inquiry is on, and to ask you, sir, to have these in mind when making future decisions. I will first briefly identify the 4 concerns in outline and then expand on them in greater detail. So, sir, the first concern, which you have already heard from many of the advocates who've spoken on behalf of non-state core participants. The non-state core participants could and should be treated as a significant resource for the inquiry in its search for the truth, not just as a source of information about their own individual cases, but in uncovering the deeper underlying themes of relevance to the inquiry's terms of reference. Their opportunity to do that is restricted on their present approach because disclosure is limited to a tiny number of individuals who are deemed by the inquiry to have a direct interest. As you heard from Mr. Menon on Wednesday and Mr. Ryder and Mr. O'Driscoll yesterday, even those few who have received the bundle were given it just 4.5 weeks prior to the start of the hearing, notwithstanding that it contains nearly 5,500 pages, and we were simultaneously all preparing for these opening statements. The police have had that material for decades, and the inquiry presumably has had it for months, if not years. So the second concern is that by restricting the cover names of undercover officers, refusing to publish the names of all of the groups that were reported on, and by delaying the publication of photographs of officers whose cover names are not restricted, the inquiry is missing the opportunity to enable members of the public to realise that they too may have been spied on, and in doing so, the inquiry fails to enable those individuals, if they so wish, to come forward to provide evidence to the inquiry. The inquiry's terms of reference require it to inquire into, and I quote, the scope of undercover police operations in practice and their effect upon individuals in particular and the public in general, end of quote. How can the inquiry purport to do that when it is closing down the opportunities for it to receive evidence from affected individuals and from the public? So the third concern in outline is that the inquiry is placing very heavy reliance on self-disclosure by the police, notwithstanding the overwhelming evidence of the police seeking to cling to secrecy at every opportunity. So the fourth concern that I will come on to address you about is with respect to you, sir, as a single individual who will be solely responsible for drawing significant conclusions about political freedoms and issues of institutional and individual racism, sexism, class, and political bias in the police and potentially beyond. With respect, these are not issues on which you have any particular expertise, but you have repeatedly refused to sit with a broader panel, at least until the final lessons learned phase. Whilst that is better than nothing, the lessons to be learnt can only be built on the facts found in the previous modules of the inquiry. If important matters have been missed or given a particular interpretation during the investigative phases, then the hands of any subsequent panel are tied in terms of the lessons to be learned. So that's then turning in more detail to the first of those concerns, the role of the non-state core participants. When Theresa May, as Home Secretary, announced the establishment of this inquiry in her written statement to the House of Commons on the 12th of March 2015, she said, and I quote, "The inquiry will review practices in the use of undercover policing, establishing justice for the families and victims, and making recommendations for future operations and police practice," end of quote. This led those who were spied on to hope that they would be at the heart of the inquiry process and that it would lead to them obtaining, at very least, disclosure of their personal files. However, it is now 5.5 years on, and with the exception of a very small number of non-state core participants, those who were in tranche 1 and the real family, none has received any disclosure from the inquiry about their situation. To the contrary, requests for disclosure of personal files have been dismissed by you, sir, as an unhelpful distraction. Not only does this run contrary to the obligations on the inquiry under the Data Protection Act 2018 and the General Data Protection Regulation, it is counterproductive for the inquiry's ability to get to the truth. If the inquiry had prioritised disclosure of personal files from the start, or if it were to prioritise this now, it would enable non-state core participants to begin the process of gathering evidence and of understanding how and when they were spied on. Importantly, it would also enable them to assist the inquiry in identifying patterns and themes, informed by the knowledge of what happened to them. On the 22nd of October 2020, just 10 days before the start of this hearing, the inquiry published a disclosure note confirming that 1, the inquiry has not undertaken any systematic search of Metropolitan Police Service records in respect of files relating to core participants affected in tranche 1. And 2, that even in respect of those personal files that it has reviewed, it did not request the whole of the file, but rather members of the inquiry legal team sought to identify which parts of the file contained intelligence originating from members of the Special Demonstration Squad, and other police reporting was considered by the inquiry to fall outside its terms of reference, save exceptionally to the extent that it went to the question of the justification or proportionality of a deployment. The non-state core participants are appalled by this approach. They have repeatedly sought to explain to the inquiry why it will not work. First, as stressed on behalf of the designated lawyers' officers in their own statement, in their opening statement, and I quote, "There is no easy way of identifying and differentiating SDS intelligence reports because they were not marked as such or overtly attributed to the unit," close quotes. Those are the words of counsel for the former SDS officers. You will have seen, sir, from a number of the tranche 1 phase 1 witness statements that many times the officers to whom particular reports are attributed are not even able to say if the contents of the report came from them. In many cases, it will only be the person who is the subject of those files who will be able to tell the inquiry what information about themselves must have come from an undercover source. The second reason why those files are essential is that all of the material in a non-state core participant's file, whether that be an individual file or a group file, is relevant to the inquiry's task, because undercover officers had access to those files. As Peter Francis has said, in order to work out how to target, and in the case of relationships, we say groom, an individual or a group. The entire contents of the file is therefore highly relevant to the question of the impact of undercover policing on individuals and members of the public. Both of these points apply equally to group files as they do to individual files. If the inquiry does not obtain the whole of the special branch and indeed MI5 personal and group files for the core participants, it will inevitably be making decisions on a materially incomplete basis. A similar problem arises from your refusal, sir, to make disclosure of the hearing bundle to non-state core participants whom you deem not to have a direct interest in a particular tranche. This means that those core participants and their lawyers do not get access to the hearing bundle until after the hearing at which the evidence is given. Now, they may not even be able to see and hear the evidence as it is given. Again, this makes it virtually impossible for those core participants to suggest relevant questions for the witnesses, and is likely to lead to applications for witnesses to be recalled once the documents have been disclosed. It is a positive development that the inquiry has very recently granted Dr. O'Driscoll, from whom you heard yesterday, access to the hearing bundle. Dr. O'Driscoll and his colleagues in the Undercover Research Group have a huge amount of knowledge and expertise in respect of undercover political policing and its impact on civil society. The non-state core participants welcome this development and hope that it is the beginnings of an acknowledgement by the inquiry of the role that non-state expertise can and should be playing in its investigation. However, Dr. O'Driscoll is just one individual, and he cannot, and nor does he seek to, represent the diverse interests and experiences of other non-state core participants. The inquiry is still a very, very long way from a position that would enable it to benefit properly from full participation by non-state core participants. In short, sir, rather than drawing on the perspectives and experience of the non-state core participants to assist and inform its lines of inquiry, the inquiry is shutting out their effective participation. Not only is this intensely frustrating and disappointing for them personally, but it deprives the inquiry of the plurality of sources and viewpoints it needs to conduct a rigorous investigation. It will also ultimately undermine public confidence in the inquiry's conclusions. So the second issue of concern that I want to address you on is the restriction of public access. As I highlighted earlier, the terms of reference task the inquiry, amongst other things, with examining the scope of undercover police operations in practice and their effect upon individuals in particular and the public in general. To date, the inquiry has refused to take the steps necessary to enable it to do that. On some limited occasions, the inquiry has taken steps to contact certain individuals when it has discovered that they were spied on in a way that the inquiry wishes to investigate, most notably when it has been discovered that an undercover officer had a long-term sexual relationship with that individual. However, the majority of your procedural decisions, sir, have had the effect of precluding those who don't already know or suspect that they were spied on from discovering that that was the case. As Mr. Ryder highlighted yesterday, The restriction of cover names is a prime example of this and is of particular concern in relation to the investigation of the National Public Order Intelligence Unit, the unit in which Mark Kennedy, the undercover officer who is now known to have had sexual relationships with at least 6 women, was employed. As things currently stand, it is understood that only 6 cover names out of 21 undercover officers from the NPOIU have been or will be published. The consequence is that the vast majority of the investigation of that unit will take place without meaningful disclosure to or participation from those who are spied on by it. The investigation will therefore necessarily be limited and one-sided. Further, even where cover names have not been restricted, the inquiry has done little to encourage members of the public to come forward if they have evidence to give. The non-state core participants have repeatedly asked the inquiry to publish a list of all the groups that were reported on by the SDS and NPOIU, so that members of the public will know if there is a possibility that they were spied on. Such a list would also be likely to increase public interest in the inquiry because it would demonstrate the reach of undercover policing. It is still a common public misperception that undercover policing has been limited to groups and individuals involved in serious criminality. Publication of the full list of groups spied on by the SDS and NPOIU would dispel that impression. As you heard from Mr. Ryder and Dr. O'Driscoll yesterday, the non-state core participants do not accept the targeting versus collateral intrusion divide. As Mr. Ryder amply demonstrated yesterday, information was hoovered up by the SDS on entirely benign and peaceful groups and retained for years. Their structures and activities were manipulated and distorted by undercover policing. That is not collateral intrusion, and those groups have a right to know what was done to them. In turn, the inquiry cannot assess the true impact of undercover policing without giving them an opportunity to be heard. The non-state core participants have also asked the inquiry, when it releases cover names, to publish photographs of the undercover officer in his or her undercover identity. Again, this would be an important means of enabling members of the public to come forward. A photograph is much more likely to enable those who have relevant evidence but who don't yet realise it to come forward. By not being more proactive in its search for non-state evidence, the inquiry is likely to miss significant information, in particular in respect of its task of assessing the scope of undercover policing and its effect on the public. It is difficult to see how that task can be achieved without the inquiry making a genuine attempt to ascertain how much public evidence might be forthcoming if only it enables people to know the full extent of the political and campaigning groups that were spied on. The designated lawyer officers urged you in their opening statement to, and I quote, expressly refute untrue allegations, exaggerated and generalized claims and conjecture, and to carefully differentiate and quantify the extent of individual and collective failings, end of quote. But how can you do that, sir, unless you enable those who would be able to give the other side of the story to come forward? So the third issue of concern is over-reliance on police documents and self-reporting. This is a source of very significant concern. The very body under investigation is being relied on by the inquiry as the principal source of evidence. In cases where cover names are restricted, it will be the only source of evidence. This is in the context of 1, policing units whose entire ethos was to keep their operations secret. 2nd, a woeful history of non-disclosure, both in the unit's original operations and in response to the reviews, investigations, and inquiries that have preceded this one. And 3, the significant wrongdoing, including now admitted human rights violations. These factors ought to dispel any presumption that any of the deployments in these units was unremarkable and not in need of rigorous scrutiny. The context in which the Special Demonstration Squad and the National Public Order Intelligence Unit operated is important, because as you know, sir, unlike ordinary, by which I mean undercover operations into serious criminal offending, their primary purpose was intelligence gathering, not criminal investigation. And this made a critical difference, because with criminal investigations, the intention from the outset is that the case will, if possible, end up in a court. The undercover officers from these units knew that his or her conduct, undercover officers engaged in criminal investigations know that their conduct will be subject to judicial scrutiny at the criminal trial. However, the spectre of oversight was entirely absent within the political policing units, because it was not their intention for their other undercover operations to ever result in a trial. This was recognised by Her Majesty's Inspectorate of Constabulary, as it then was, in its 2012 Review of National Police Units, which provide intelligence on criminality associated with protest. And sir, I have set out in the group's written opening a relevant quotation from that report, which I won't read through now, but I would ask you to consider, sir. In short, the undercover officers deployed in the political policing units knew from the outset that it was very unlikely that they were ever going to have to account for their actions. And this led inevitably to a culture of impunity and an absolutist approach to secrecy that was untempered by the principles that would ordinarily flow from interaction with the courts. And therefore, when there was interaction with the courts, this resulted in the non-disclosure and miscarriages of justice that you heard about from Mr. Ryder yesterday. This culture of secrecy is so ingrained in these units that it's incomprehensible that the police records and evidence should now be approached by this inquiry as a reliable and in some cases exclusive source of information about their activities. This skepticism is borne out by the fact that there have been at least 19 investigations and reviews into the activities of one or other or both of these units, and none has succeeded in getting to the full truth. Frequently, the limited findings of one investigation have very quickly been undermined by a subsequent discovery of non-disclosure. In 2014, the Stephen Lawrence Independent Review, led by Mr. Mark Ellison QC, was highly critical of the level of record keeping within the Special Demonstration Squad and identified material non-disclosure to the Macpherson inquiry. As you know, sir, Mr. Ellison found that the SDS had had a spy, an MPS spy, in the Lawrence family camp and had arranged for that officer to meet with a member of the MPS inquiry team at the time that that team was drafting the Commissioner's final written submissions to the inquiry. None of that was, of course, disclosed to the Macpherson inquiry, nor was it the only material non-disclosure to that inquiry. Relevant intelligence arising out of Operation Orfona, an internal anti-corruption investigation, was also withheld by the MPS, notwithstanding 2 written requests from Sir William Macpherson in relation to such material. Further, the MPS's own internal review into that non-disclosure was itself partial and misleading. Mr. Ellison described the internal review as, and I quote, "another example of the MPS providing misleading reassurance to the family and to the public. In effect," the review claimed, "it's all right, we've looked at it all again, there's nothing new, and there's no material indicating possible corruption that was not revealed to the public inquiry." End of quote. In other words, it was not just that there was a problem with non-disclosure to the Macpherson inquiry, but that when the MPS had the opportunity to put its house in order through its own internal review mechanism, it failed to do so. As Mr. Barr noted in his opening statement, Mr. Ellison also found that the MPS had gathered and disseminated within its organisation intelligence on Dwayne Brooks relating to divisions between himself and the Lawrence family, the way in which he was going to approach his defence to criminal charges, and his expectations for his civil claim against the MPS. Again, this has echoes of the examples Mr. Ryder took you through yesterday, sir. In Mr. Brooks's case, Mr. Ellison noted that some of the reporting included information about the complainant in criminal charges against Mr. Brooks, including material that undermined the complainant's position. Mr. Ellison found that no consideration appeared to have been given to the potential disclosure of that reporting in the criminal proceedings, and that had disclosure not occurred by other routes, it is possible that material non-disclosure might have occurred. Mr. Ellison also raised questions about the motives of the MPS, both in relation to the prosecution and in their obtaining of intelligence in relation to Mr. Brooks's civil claim. So in addition to concerns about material non-disclosure, there are also concerns about the destruction of records. As Mr. Menon raised on Wednesday, there is evidence that documents relevant to this inquiry were shredded by MPS personnel in May of 2014, after the intention to set up this inquiry had been announced and after a command circulation had been issued specifically stating that such material should not be destroyed. This allegation was investigated by the Independent Office for Police Misconduct in Operation Hibiscus. The IOPC published its findings in November of 2019. Not only did it find that there was sufficient evidence to support a conclusion that material relevant to this inquiry had indeed been shredded, it also found that an officer of the MPS Directorate of Professional Standards had been informed of this, but had delayed taking any action in respect of it. The IOPC also expressed concerns that a number of managers within the MPS had refused to engage with its investigation. It is of great concern to the non-state core participants that there has been no public condemnation by the inquiry of the conduct uncovered by Operation Hibiscus. Similarly, the discovery that a former undercover officer, whose cover name is James Straven, lied to the inquiry, not once, but twice, in signed witness statements in support of his application for restriction orders. And this does not appear to have in any way altered your approach, sir, to the similar assertions of other officers denying that they engaged in intimate relationships whilst deployed. In granting restriction of cover names, you, sir, have repeatedly asserted that the relevant deployment appears to have been unremarkable, with no acknowledgement of the fact that you cannot know that without disclosing the cover name, so that those who could give evidence to the contrary are able to come forward. It is shocking that an assumption that a deployment was unremarkable should play any part in justifying restriction of a cover name, when such restriction has the effect of preventing the inquiry from effectively investigating the very thing it should be inquiring into. The Metropolitan Police's extreme resistance to disclosure in relation to the activities relevant to this inquiry, including the level of institutional knowledge about undercover officers conducting intimate relationships, will be addressed by Philippa Kaufman QC on Monday in the context of the concerted efforts made by the MPS to avoid making any form of disclosure in the civil proceedings initiated by the women. So I will not rehearse that history now, but I would ask you, sir, to bear it in mind. I will say now that in light of all of these factors, the non-state core participants have no confidence that the police will volunteer full disclosure in this inquiry. There may be some tactical disclosure of individual wrongdoing, but in order to excavate the deeper systemic position, the inquiry will need to draw on information from other sources, including the non-state core participants. Worryingly, the culture of secrecy in respect of the SDS does not appear to be limited to the Metropolitan Police. As has been noted in many of the opening statements, an issue of significant importance in this inquiry, particularly in relation to the establishment of the Special Operations Squad and its transition into the Special Demonstration Squad, is the role played by the Home Office. As you have heard from others, sir, in the wake of the findings of Mark Ellison QC, the then Home Secretary Theresa May commissioned a review into the full extent of the Home Office's knowledge of the SDS. Counsel, on behalf of the Home Secretary, mentioned in his opening statement some of the findings of that review, but he did not mention the fact that Mr. Taylor found very little documentation relating to the SDS within the Home Office's own records. Mr. Taylor recorded that there was a consistent Home Office file reference relating to the SDS, but concerningly, the contents of that file were untraceable. Mr. Taylor found, and I quote, "There is no record to show where this file is or when it may have been destroyed. The absence of any current record of this reference number in departmental records is a concern, given that the material would have been classified as secret or top secret. It is not possible to conclude whether this is human error or deliberate concealment." Again, this raises real concerns about the lengths taken to maintain secrecy in relation to the SDS and highlights the problem the inquiry will face in attempting to reach conclusions founded on the state records. So the fourth concern is with respect to you sitting as a lone decision maker. The non-state core participants have real concerns that you, sir, sitting alone to determine the issues of fundamental importance which arise in this inquiry is simply not the way to get to the truth. You will be called on to decide questions around political policing, institutional and individual racism, sexism, class, and political bias. The inquiry's terms of reference require it to reach decisions about the motivation and justification for undercover policing operations. In respect of the vast majority of the groups spied on by the SDS and the MPOIU, those are inherently political questions. With respect, sir, you have previously made comments which are indicative of a dismissive view of groups whose political ideologies differ from your own. And these will be referred to by Ms. Kaufman QC in the opening statement on behalf of John Burke-Moniville, Patricia De Silva and Mark Wadsworth on Monday. This is a matter of real concern in an inquiry where you will be drawing conclusions of such profound importance to fundamental freedoms, including where the line falls between freedom of political belief and expression on the one hand, and activities, if any, capable of justifying undercover policing on the other. As you have heard, sir, the annual reports from the early years of the SDS record groups such as the anti-apartheid movement and the women's liberation movement amongst those that were infiltrated. From today's perspective, it is shocking that such groups would be viewed as subversive, let alone sufficiently so to justify being subject to intrusive undercover policing. With respect, how are you, sir, as a lone individual, equipped to make decisions about which movements and campaigns, if any, were and were not justified as targets, especially as the inquiry moves towards the present day? And on what basis can such determinations be made in cases where those who are spied on are not given an opportunity to give their own account, as will be the case where officers' cover names are restricted, or where full disclosure of group and personal files is not made? The inquiry will also have to confront and address the extent to which racism, sexism, class and political bias were at play in the targeting and conduct of undercover policing operations. Again, with respect, sir, these are not issues on which you have particular expertise or experience, and you have to date rejected calls for a diverse panel to share the decision-making with you during the first two modules of the inquiry. This is of concern because finding out what happened, particularly when evaluating motivations and justification, is not a value-free process. You, sir, as do we all, will inevitably bring to bear your own life experiences and beliefs. There is now a considerable body of contemporary scientific research demonstrating how unconscious biases affect decision-making in all fields, including judicial fact-finding. And again, Ms. Kaufman QC will address that research in greater detail on Monday. A panel with a diversity of backgrounds and experience would be an effective means of ensuring that unconscious biases are identified and challenged. If you are to sit alone, sir, you will bear the heavy burden of having to scrutinise and challenge your own preconceptions. That is a task made more onerous by the inquiry's lack of transparency and public access, and its one-sided reliance on state records and evidence. Not only are you disproportionately exposed to only one side of the story, but by minimising non-state and public participation, you reduce the opportunities for external scrutiny and challenge to your own assumptions and decision-making. So, before I conclude, there are 2 points that I wish to make in response to the opening statement on behalf of the designated lawyer officers. First, sir, counsel for the designated lawyer officers urged you to guard against judging 20th century actors by 21st century standards. In doing so, he referred to the report from the Select Committee on the petition of Frederick Young and others from the 6th of August 1833. He described this in his oral statement as your predecessor committee, and sir, in many ways it is. Counsel for the designated lawyers referred to it as supporting the lawfulness of undercover policing. However, I would ask you to look at the report in detail. Interestingly, it concerned the covert infiltration by a police officer into local meetings of the National Political Union of the Working Classes. The officer concerned, Officer Poppe, was said to have, whilst undercover, taken an active part in meetings and to have attempted to incite participants to violence. He also deceived his way into people's homes and manipulated their empathy and generosity. Some parallels with the accounts you have heard yesterday and on Wednesday and today in relation to the SDS and the MPO at you might find. It is right, as counsel for the designated lawyers said, that the 1833 Select Committee did not find undercover policing to be unlawful per se. However, it found Officer Poppe's conduct to be deserving of the committee's most grave and decided censure. The committee observed that the employment of policemen in plain clothes must be, and I quote, strictly confined to detect breaches of the law and to prevent breaches of the peace, should these ends appear otherwise unattainable, end quote. What the Select Committee went on to say is also critically important, and counsel for the designated lawyers did not cite this part. I quote, at the same time, the committee would strongly urge the most cautious maintenance of those limits and solemnly deprecate any approach to the employment of spies in the ordinary acceptance of the term as a practice most abhorrent to the feelings of the people and most alien to the spirit of the Constitution, end of quote. So, sir, the public shock and concern about this type of political undercover policing is not a modern day sensibility. In 1833, a select committee of the House of Commons was identifying the need for a strict necessity test, tightly confining the purposes of undercover policing and recognising that its use more generally is abhorrent to the feelings of the people and most alien to the spirit of the Constitution. That must be right, sir. Political undercover policing is not just a binary balance between the right to protest and the maintenance of public order, as counsel for the designated lawyers appeared to suggest. The degree of intrusion into people's lives occasioned by the political policing goes to the heart of political and individual freedoms, not just the right to demonstrate publicly, but the right to a private realm in which people can discuss their beliefs and values without being surveilled and blighted by the state. It is beyond irony that counsel for the designated lawyers speaking on behalf of secret police officers should use the word totalitarian to describe the people that they spied on in their homes, in public houses, in meeting halls, for advocating on issues such as sexual equality, anti-racism, social and political justice, and environmental change. Abhorrence of that type of political policing is not a 21st century development. The second point I want to raise, sir, is in relation to the Supreme Court decision in the case of Cat. Several of the state openings have made reference to the speech of Lord Sumption in that case. However, it's important to remember that Cat was not a case about undercover policing. The information recorded about Mr. Catt was obtained through open observation at public events, and Lord Sumption made clear that that was the starting point of his decision. Second, the information gathered was not usable or disclosable for any purpose other than policing. It expressly would not be disclosable for any vetting or employment purpose. Third, it was not held on any personal or nominal file relating to Mr. Catt, a matter which Lady Hale said would have altered her view of its lawfulness if it had have been. All of these factors underline the difference between the type of intelligence gathering under consideration in Catt and the far more intrusive activities of the SDS and the MPOIU. And you will know, of course, sir, that when Mr. Catt took his case to the European Court of Human Rights, that court found that the retention of even the overtly obtained information about him had been unlawfully retained. So, sir, in conclusion, the non-state core participants want this inquiry to succeed. They want it to be able to get to the truth, and they want their participation to be meaningful. They want to discover what was done to them and to understand the extent to which undercover policing, political undercover policing, has affected and distorted civil society over the last 50 years. They want their voices to be heard, and they want the inquiry to take seriously the plurality of views and lived experiences of those who have been subjected to political undercover policing. They want lessons to be learned for the future so that political freedoms and private lives are properly protected and that others are not subjected to the gross abuses that many of them have suffered. To this end, sir, they ask you to bear in mind the following demands. 1, to facilitate proper public access to the inquiry's proceedings. 2, to enable non-state core participants to participate meaningfully and effectively by giving them disclosure of their personal and group files, access to the hearings and to the documents in advance, and I would add sufficiently in advance to enable them to properly prepare, so that they can assist the inquiry with themes and questions. 3, publish the full list of groups spied on, and by that they mean all of the groups reported on, including those that are claimed to be collateral intrusion. 4, publish photographs as well as cover names of undercover officers so that members of the public can know if they were affected. And 5, to expand the panel, or to consider inviting the Home Secretary to expand the panel to include a diversity of expertise, perspectives and experience, not just for the lessons learned stage, but now, as soon as practically possible. Sir, without those things, it is difficult to see how the inquiry can deliver on its promise to get to the truth. Thank you. Those are my submissions.